5 seconds to go. Start. If the word communal is interpreted as the community of the beneficiaries of the group development, then it must be understood as meaning that members of the general public cannot be permitted to partake of the benefits flowing from the open space reservation. For instance, if adjoining the site and as indicated in the explanation in a shape and location determined by the CMDA, a park is constructed by use of the word communal and interpreting it to mean a community which is larger than the mere beneficiaries of the group development as such, then the benefit of the open space may become available to the general public in the nearby area. This would have the advantage of facilitating the members of the public avoiding travelling to the areas where there is recreation or open space, as for instance under the zoning requirements. Undoubtedly, the absence of any construction which is indispensable to make it an open space area and which is insisted upon also will provide a large chunk of space for all the people in the area, making available the facilities on the basis that when development is permitted, it brings in its train certain responsibilities for the project proponents which can be appreciated as legitimate state interests is one way of approaching the issue. It must be understood in all these cases that setting apart of 10% of the area is actually as such not objected to. This means all parties are agreed that the law providing for setting apart of 10% of the total area excluding roads in the case of group development in excess of 10,000 square meters is legitimate and valid unless we find favor with the arguments that it is otherwise constitutionally infirm. We have already found that the provision does not offend Article 14 on the ground that it represents a species of class legislation. We are unable to also find that the provision is manifestly arbitrary. If, in other words, there is no other basis to find the impugned rule vulnerable, we can safely proceed to hold that the requirement of OSR is not unjustified. We have noticed the stand of the two appellants and the writ petitioners also in this regard. We find that it is their stand that they are prepared to maintain the 10% area as OSR. What is objected is to the execution of the gift deed and allowing the property rights to change hands. This is apart from the objection to the chosen site being made accessible to the general public. We have noticed that in Pandit Chetram Vasistha Supra, this court has held that in the absence of valid provision under which the gift in the said case could be supported, the mere resolution was not sufficient. The position still was found to be that the original owner would continue to be a trustee. He cannot transfer or change the nature of the property. In fact, in the decision reported in Virender Gaur Supra, this court discountenanced conversion of what was an OSR area into land on which construction, though for what was projected as a laudable object, was carried out. We are of the view that bearing in mind the laudable object, the law relating to town planning, which has been the very basis for our reasoning otherwise, we must clarify that what the rule and the regulation mandatorily stipulated was the dedication and maintenance of 10% of the area for communal and recreation purposes area only. There is inviolable duty on the part of all, including the local body. Stop.